And these three...
Including the Colorado state constitution,
yes. Well,
which has things in it like Article 10, Section 20, which is the Taxpayer Bill of Rights, which this Supreme Court has ruled almost every time against.
Every time.
Yeah.
They are the 2008 Detroit Lions of the judiciary. 0 for 15. And there's another case coming up. There's another tax case. So they could equal the 2008 Detroit Lions record of 0 for 16 of upholding your constitutional rights under that Article 10, Section 20.
So let me go through a couple of the rulings that just blow my mind from this court, and it shows that they're out of touch. You remember a couple of years back, I think it was 06, when let's see, it was Tom Tancredo and Dick Lamb and also John Andrews put together something called the Defend Colorado Now initiative. This was an anti-illegal immigration initiative. The Denver Post hated this initiative. I mean, they despised it. They were seething about it. And they brought it through. They got their signatures. And at the last minute, the Supreme Court said, no, I'm sorry, it's a violation of single subject, even though a year earlier they had basically the exact same thing, and they said, oh, it's fine, it's a single subject.
Yeah.
So
at that
egregious.
Time they delayed that ruling so late that it couldn't get on the ballot.
They delayed the decision that there was no way to get it back on the ballot.
Right.
But just to validate what I'm saying, the Denver Post, who hated this initiative with every fiber of every paper they had, went on to editorialize that this was a purely political decision by the Supreme Court.
Absolutely.
You know, and to look back at, for instance, the 08 ballot where they allowed the anti-Tabor amendment by Andrew Romanoff, which had 15 different subjects in it.
Right.
You know, the idea that there's a single subject that should be allowed for citizens' initiatives was blown apart. On 1 year, if we don't like it on immigration, that's fine. And even the Denver Post says it's out. But the year later, we'll say, oh, if you want to include amending this part of the Constitution, that part of the Constitution, and this part of the Constitution, it's fine.
Yeah.
So even when the Denver Post says they went too far, they went too far. Talk to me about some of the Tabor rulings.
Then that was that case you mentioned is one of the key constitutional cases that I have up on my site. So people can read about that case, commentary on the case, people that talked about that. They lambasted, and as you said, the Denver Post editorialized. Horrible ruling. It was a blatantly political play by the Colorado Supreme Court. And that is exactly the problem. We have these people that should be judges, that should be fair and impartial referees, deciding instead they want to be players. They are politicians in black robes, hiding behind the pretense of being referees. They are partisan players. They have politicized the court for well over a decade. The rulings we're talking about, the one that really grabbed my attention and caused me to do more research, and the more I dug, the more rot I found, was, of course, the 2009 mill levy tax freeze case, so-called. That was the unconstitutional property tax increase. This is a 2007 piece of legislation that was passed, challenged, overturned in the court by a lower court, a Denver District Judge, Christine Hobbs, who held correctly. And despite her own personal preferences, you know, in her ruling, she would say, look, my sympathies are with the intent of this legislation. And I like children.
In all full disclosure, people need to know that this was the case that the Independence Institute and I brought up against the state of Colorado. When the state of Colorado and the legislature, Bill Ritter, signed into law something that said we're going to raise your property tax mill levy.
Right.
But we're
going to raise it.
We're not going to just freeze it.
When it happened to have bounced up to about as high as it's ever been.
When it was about ready to fall, we're going to freeze it. Well, that sounded nice, but it turned into a tax increase.
Right.
We brought forward a suit. Judge Hobbs ruled, as you said, I don't like ruling this way. I hate this. I want the state to have the money, but this is a clear violation of the Constitution. And in fact, our own state treasurer, Kerry Kennedy, under oath said, yes, this is a change of tax policy, which brings in more money. And when you read Tabor, it says, if there's a change to tax policy which brings in more money, you have to ask the people first.
Right.
Well, bring it up to the Supreme Court, and they said, we don't care about that.
No, and the ruling on this is just, it's a brilliant exercise in creative writing, because they basically invented mind reading or time travel or both to go back in time and justify this unconstitutional ruling by saying, well, local jurisdictions had held local votes on local issues, and that constituted prior approval. Despite the fact that these local governments were the ones.
We got a couple minutes left here,
it.
so let's put in the other cases that people might be interested in. Now, they might love the mill levy tax raise. They might hate the attack on illegal immigration back in 2006. So they're saying, hey, this is fine. It works out the way that I wanted it to work out. Why should they still be skeptical?
Well, in general, you should be skeptical whenever you just toss aside the rules and you rule by majority. It's not, judges are not supposed to be politicians. They're supposed to be applying the law fairly and impartially. And if it gets to the point where you have essentially tyrants in black robes sitting on a court and being able to impose their will just because they can collect enough votes, you no longer have the rule of law. You no longer have constitutional limits on government power. They can pretty much do whatever they want to you. And another case, you know, the car tax case, another one that said tax increases don't count as long as you call them fees. So we've seen an explosion of new fees, the car tax being the most famous one.
Well, we've got a minute left here, so let's try to wrap this up. I tried to bring somebody here who might disagree with you on this. We've spent a lot of time doing this, and they didn't want to because either you're so wildly silly that you're not worth talking to, or they just didn't want to talk about it. I have heard a whole bunch of ads from people saying, you know, read the blue book. Just read the blue book. And of course, the blue book says
Rubber stamp.
Vote yes for everybody.
100% of the time.
Who's spending all the money for these radio ads that I've been hearing?
Well, it's a mix of a whole bunch of legal establishment and special interest groups. You've got the Colorado Bar Association, reliably left-wing. You have the Colorado Judicial Institute, which is supposed to be a nonprofit, but oh, by the way, sitting on the board of that group, Justice Michael Bender.
So Michael Bender, who's up for retention, is part of an organization that is paying for ads to say, read the blue book, which says, retain me.
Right.
Nice.
Nice little bit of skirting around the edges of campaign finance law.
Out of time, people want to get more information. Where do they go?
clearthebenchcolorado.org and read some substantive evaluations. We were endorsing that by Vincent Carroll, the Denver Post, the Pueblo Chieftain, Mike Rosen.
Clearthebenchcolorado.org. And at least vote on these justices. It's your right and your responsibility. Tell a friend. We'll see you next week.